Good afternoon.
Yes, Mr. Jude.
My Lord, my Lady. I was going to now move on to clause 12. Clause 12 argument. Variation
Yes.
under clause 12. And I'm going to start with the contract sum, because that is absolutely critical in this case. If the contract sum has not been altered, then the taxpayers can't win because they have to have incurred expenditure under the contract. And if the contract sum has remained what it was, then they have not incurred that expenditure at the relevant time. Because the expenditure they incurred was 58 million.
Yes.
The contract sum under the unamended contract was 102 million pounds under works option 1. So unless that itself can be varied, altered by the clause 12 instruction, then this tax effect cannot be achieved. That was something that I hoped I made clear in opening.
Yeah, although I think you accepted, if I remember rightly, that clause 12 can pave the way for an adjustment to the contract sum, because if there are additional works or omitted works or whatever, then the contract sum may need to be adjusted.
Yes. If that happens, subsequently the contract sum can be adjusted under those terms, but not by the instruction by the employer, was the point I'm making. Because those alterations under clause, I think it's a new clause 23A that was introduced. Yeah. They are all started off by the contractor saying, I need more, need to be paid more, essentially. And then there was a whole process under clause 23A, which may result in an adjustment subsequently to the contract sum. But that's not what we're talking about here. What we're talking about is whether on the 1st of April, the employer could, by instructing, as they did, alter the contract sum, i.e. the amount that's due under the contract. And we say they couldn't. And that is absolutely clear. A number of provisions. One of them is one I mentioned. I'm not sure I actually took you to the actual provision, but it's clause 13 of the standard form.
Of the JCT? Of
the JCT. This follows clause 12. It's on page 520 on the, if you've got the supplementary bundle. It's internal page 25 of the JCT.
Yeah.
Which provides the contract sum shall not be adjusted or altered in any way whatsoever, otherwise in accordance with the express provisions of the condition. So it's simply not possible by an indirect means, by adjusting the employer's requirements, to alter the contract sum.
But doesn't that, in a sense, beg the question? If clause 12 can alter the employer's requirements in a way that has an impact on the contract sum, which is what Mr. Williamson argues for, then it is being altered in accordance with the express provisions of the conditions, isn't it?
Well, in my submission, no, because an express provision which allows alteration would be an express provision that refers to the contract sum being altered.
Oh, I see.
Not a provision that has that effect. That's the point about this. Point about Article 13. It's saying you can't do it by the back door, by some other means, through other provisions. It's only altered where the conditions actually say so. Which is not very surprising, really, because the contract sum is obviously a very important basic amount. And there are, as we know, there are provisions in the conditions and as varied that do allow it to be altered, but only going through a process which can end up in adjudication, I think, in the end. So my submission in opening was that it cannot be the case, as a matter of construction of this agreement, that the employer unilaterally can alter the contract sum by issuing instruction under clause 12. And I bolstered that by pointing out that when you look at clause 12 itself, the only things which require the consent of the contractor are changes which make necessary an alteration or modification in the design of the works. So not the contract sum. Now we say that's because the contract sum is not something you can alter. But if you could, then it would not be subject to the consent requirement of the contractor, which would be even more absurd.
But if a modification to the design or a change to the scope of the works ended up in less money having to be expended, then surely it would follow that the contract sum would be adjusted accordingly. Otherwise, the employer would be paying over the odds.
Well, the first point to make, of course, is the employer is deliberately is doing this himself. But there may be a provision it may be that clause 23A could be operated in some way to allow the employer to say, I should pay less, but you would still have to go through the process of agreement or adjudication, whatever. The employer couldn't simply say, I want a bit less done, and I'm only obliged to pay X less. I mean, otherwise the employer could in effect frustrate the contract, having changed his mind as to whether he wanted this work done.
Well, I fully take the point that the employer, having contracted with the contractor to pay him, say, 100 million for particular work, couldn't unilaterally suddenly turn around and say, I'm not going to pay you 100 million, I'm now going to use clause 12 so that I only pay you 64. That I entirely understand.
This is what they've done exactly in this case.
Well, yes, but if they have, within the scope of clause 12.1, modified the works that they've specified, or modified what is actually going to be built under option 1, legitimately, shall we say, leaving aside the question of whether they can alter the works themselves.
Yeah.
Then, speaking for myself, I can't see why, if that produces a modification of the contract sum, they can't claim the relief in relation to the lower sum than the relief that they would have been entitled to for the higher sum. Because they're still expending that money on the construction of a building in an enterprise zone. And on your case, it's still the same building, it's just got different bells and whistles added, like an extra floor, or...
I see. Sorry, what?
Or it's been modified so that it's not as much. In this example, it's modified the other way, so there's not as much of it. Yeah. But they haven't. But if they alter the contracts, I mean, we're now talking about applying it to this case rather than the generality, this type of case. But if they alter the contract sum, what I'm assuming is that they haven't altered the contract sum. And my argument is they haven't validly done that because they can't do it. Well, I follow that, but I was just testing that premise, or testing the argument, by saying, well, let's suppose they make an entirely legitimate change to the specification of what they want in relation to works as already defined, but it ends up with less building work having to be done rather than more building work having to be done. We know there's a special contractual mechanism that deals with more, and you've shown us that, clause 23. If it ends up with less, and the result is that you expend less, or need to expend less money in fitting it out, for example, then why must they be wedded to the original 100 million? Why shouldn't they only be entitled to relief on the 54 million?
Well, they're not. So I think we have to distinguish two cases. One is this type of case, where they've paid it all up front. And then you have to ask, well, have they incurred the expenditure, the contract sum under the contract?
Yeah.
If you're talking about a more straightforward case where they enter into a contract for 100 million and then subsequently only spend 50 before, then of course they would only get relief for 54 because that's what they incurred.
So this argument goes to the question, is it the same contract? Is that...
No, this goes to the question, have they incurred the expenditure under the same contract? So I have the incurred expenditure exactly under the same contract, i.e. the golden contract. And on the hypothesis that there's no variation to the golden contract as regards contract sum, leaving aside the other parts, then the contract sum is the higher amount still, and therefore they haven't incurred this expenditure under the old contract.
So it goes to the question under the contract.
It's under the contract, yes. That's why it's relevant as to whether the contract is varied or not. If the contract is not varied, sorry, that's why it's relevant whether the contract is a new contract comes into existence or rescission or whatever. Because if that does happen, then it's not under that contract. But in this case, what they're saying is, well, we varied the contract under clause 12 at the time, at the 1st of April. We varied it in two ways. One was to change the works, and we'll come back to that. But the other was to, crucially, was to change the contract sum. So they changed both of those unilaterally on that date. Now, if they did achieve that validly, then of course they did incur. They would have incurred the expenditure of the 58 million that they paid under the original contract. It's simply been altered within the terms of the contract. But if they were not able to do that, then the position on the 1st of April would have been they hadn't varied the contract sum because they weren't able to do that. The contract sum was still what it was under the contract, which having elected for option 1 would be, option 1 would be 102 million, I think, something like that. So they haven't incurred this expenditure under that contract. What they've done is paid a much lesser amount on the basis that they are varying the contract to something else. That's the point I'm making. So in my submission, they do have to vary both the works and they have to vary the contract sum in order to succeed at the point we're talking about. Well, you have to remember, my lady, that the qualification we're talking about is only a stepping stone to the qualification for the allowances in this case by the LLP. So it's asking whether they would have qualified at the time that they incurred the expenditure, which is the 1st of April, say. Because that has to happen before they sell the relevant interest to the LLP. 4 days later, 3 days later. If we didn't have that step, the question about whether they incur expenditure would be, you'd be looking at it as it goes along. They wouldn't be able to claim allowances if they entered a contract for 100 million, but they only actually incur expenditure of 54. They can only pay, and that's what they pay. They can only claim allowances for 54 in the end. But that's a different situation. That's going to be like a straightforward situation where you just enter into a contract and have the building built. So the amount that you'll be able to claim would be obviously limited to the amount you actually incur in that case. But here they're saying they incurred it all on day 1, April the 1st. So we say that's the first problem. Just dealing with one point my learned friend made about the construction of clause 12. He seemed to be suggesting that this was fine because this is what these parties had agreed. It may be very extreme, it may be you may find it odd, that's what they agreed. But you do have to remember this is a JCT joint standard form contract. Thousands of people will have agreed on these terms. Hundreds of tens of thousands possibly, I don't know how many. So if you were to say that's the construction of that, then it will obviously not just affect this case, but it will affect thousands of other cases. It's not bespoke to this case. They haven't produced their own variation type provision. They have amended it to some extent, but the basic provision is from the JCT. So then, can I come to the question of the works and whether they can be varied? And I think, as my lady Justice Andrews pointed out, there is a certain circularity to this argument. And the question is, how do you break out of the circle? And in my submission, the answer is to be found in Article 10 in the contract.
Which contract are we looking at now?
It's the actual contract between
Yeah.
the developer and the contractor, and it has a number of articles at the beginning. I don't know if these are the ones you don't have in the version you were looking at, my lord. Right at the beginning of the contract, after the recitals, there are 10 articles of agreement.
No,
You have to look
they're in this version of it. Where's
It's in Bundle B,
Bundle B?
and it's on page 545, which is behind tab 20.
I think I moved mine over.
This is a provision I did show you, in fact, in opening
Yeah.
class. I would say it's page 545, it's Article 10.
Article 10, is it?
Yeah. So what my learned friend says
Oh yes.
is Article 12 allows you to vary, to amend, and modify the employer's requirements. And he says that therefore can have the effect of overriding the contract terms. But in my submission, this makes it clear that that would not be the case, because it provides where there's a discrepancy or conflict between the contract documents. The priority is as follows: first, this contract; secondly, the conditions as amended; third, the supplementary provisions; fourth, the employer's requirements, contracts, proposals; and fifth, contract sum analysis. So what this shows is, although you can amend the employer's requirements, which is all about the design, whatever, if that conflicts with the provisions of the contract, then the contract takes precedence. So I think that breaks the circularity, if you like. And it's probably what the Upper Tribunal were getting at, although they don't rely on this provision. In paragraph 78, where they're talking about the employer's requirements existing as part of, subordinate to the contract. So all one can do is alter the employer's requirements as far as they are not inconsistent with the contract. And the final point is a simple factual point. My learned friend places all the weight. What he says is, it's important exactly what's in the employer's requirements, because whatever they put in that can affect the contract. Even if that's right, which I hope I explained is wrong, we don't know what was in their employer's requirements, the relevant ones. That's the document we don't have. And it's no good to say, as the Upper Tribunal said, well, you can just look at what was built, because we are asking a very particular question about what the position was on the 1st of April when the change order took place. What effect did that have on that date on the contract? Not what the position was many months later.
Well, maybe one doesn't look at what was actually built, but Mr. Williamson says, well, we may not know exactly what the employer instructed the contractor, but we do know that what the contractor instructed the subcontractor, and it's overwhelmingly likely that the same instructions will pass down the hierarchy of contracts in the contractual chain. That would be a permissible inference, wouldn't it?
Well,
for the Upper Tribunal to draw in circumstances where the primary document, so we are told, has been lost, and they are using secondary evidence to reconstruct what the primary document would have said.
Yeah, well, first of all, that's not what they did. In fact, they didn't do that, because remember, Mr. Pulford gave evidence and said they might have been similar, and they said we don't need to resolve that because we know what was built. So they didn't follow that course. But in my submission, that would not have been legitimate, because what we're looking at here is, in Leonard Friend's case, whether the terms, the precise terms of the employer's requirement varied the works options and the contract sum, if he says he can do that. And so what they actually said, and we don't know what degree of particularity they were in at that stage. Remember, this is almost a year before the actual employer's requirements were sent out to the subcontractors. We've no idea what level of detail there was in the employer's requirements at that stage, or what they actually said. And to say, well, that can have the effect of overriding the contract terms on the basis of a document we haven't seen, seemed to me just simply wrong in principle. You would be inferring that it had terms that were sufficient to override the contract, which is, you're almost going back to this idea that they must have intended to achieve what they wanted. Yeah. But in any event, I say it doesn't matter what they said, because legally they couldn't achieve what they were trying to achieve.
Yeah.
And now that this, I think perhaps moving on, I was going to move on now to the contractual variation. But an overarching point perhaps to make about all of this is my line friend's constantly talking about, was constantly referring to what would happen between parties in an ordinary commercial situation. And of course we have no problem with that. That's not what we're arguing about here. If two parties decide to change the terms of a contract they've entered into, nobody, unless there is some external party like the revenue who's interested in whether it's the next same contract, nobody is going to say anything to them. They're perfectly free to change their contract, and whether if there was a dispute, it would be held to be a change, or held to be a rescission, or held to be a variation. It doesn't matter. The parties will just carry on, and as long as they know what the terms are, it doesn't matter. I mean, it occurred to me it was a bit like the Schrodinger cat sort of thing, or the particle physics. Does it really exist if nobody asks the question? I mean, it doesn't matter, does it? There isn't in any real sense, a rescission or a variation if the parties don't care and nobody asks the question. But as soon as somebody asks the question, then as a matter of legal analysis, it would have to be answered. And that's what we have to do in this case. So nobody's suggesting that the parties aren't free to contract and to change their contracts however they like.
I mean, there are, I suppose, logically, three possibilities. One is they didn't vary the contract at all. They just implemented its terms. The contract says you can give a notice under Clause 12, and it prescribes these effects. And so there's no variation of the contract. There's a performance of the contract.
Yeah.
And that might matter not just in a legislative context, but when you've got a guarantor, for instance, who says, well, I want to say you varied the contract, and therefore I'm no longer liable. The retort may be, oh, we haven't varied it, we've just implemented it in a particular way, which is contemplated by the contract. The next possibility, I suppose, is there has been a variation, properly so called, and the third is that there is a different contract, whether you call that a rescission or a new contract may not matter, but it's not the same contract.
Or the fourth possibility is that simply nothing happened on the 1st of April of any legal significance at all, because they didn't make a valid change under Article 12, and they didn't make, which I'm just going to come on to, a contractual variation at that stage. But none of that matters, as I say, commercially, because 3 days later, as I said, they entered into the SDA, and we've looked at those terms. I don't think my learned friend looked at the provisions I looked at and said anything about them, but we looked at them, and under that provides everything. All the contractual requirements to build the building are there. So no one's suggesting that there wasn't a contract to build the building. There clearly was. That only we say that happened 3 days later. Now, my learned friend objects to this and says it was a new point, but really what it is just a point answering the way that my learned friend's put his case, which is, look, this has to have happened, because otherwise there'd be nothing under which the building was built. We've got to magic a contract into existence. And we say, no, you don't, because there is a perfectly good contract, which, if you look at its terms, is intended to be the contract under which the buildings were built and refitted. Because it continually referred to under the terms of this agreement, if you remember. They were building the building under the terms of this agreement.
Yeah.
So it was clearly what was intended commercially to be the contract. Can I then move on to contractual variation? And my learned friend complained that our case has changed in some way on this. But to understand the position, you really have to go back to what the LLP's case was before the Upper Tribunal. And I did show you this previously, but if you just look at paragraph 71, it's summarised by the Upper Tribunal in paragraph 71. Either it was clause 12, and that was their primary case, or secondly, even if the change orders were not given pursuant to clause 12, then the intention of the parties at the time of the change orders was to effect an amendment to the golden contract, not to rescind it. So what the revenue was facing was an argument that says it's all based on intention. This was the intention of the parties. And that's why Morris and Barron and all these cases were relevant as to what does intention mean in this context. And we said it had to be the intention which you detect objectively by looking at what people say and do, not what was in people's minds or what you can infer was in their minds. That was the argument. The argument was not that the contract came out of an offer and acceptance, the offer being the instruction of the change order, the acceptance being not sending the money back, essentially, and building the building. That seems to be the case now as to how the contract came about. I think my learned friend accepts it doesn't just come about because of the intention of the parties. So the response to that case, that's why we say, well, that can't be right, for a number of reasons. And can I just take you briefly to something which I think is probably not controversial, but it's just useful in this context. It's the case which my learned friend referred to in passing, where he talked about the parties being the master of their own contractual fate. It's a decision of Mr. Justice Bingham in a case called Pagnan, which is an authorities underlay tab 14. And it's page 610 in the report, which is page 269 in the bundle. The passage is in fact on page 270, you see in the first column at the bottom. But I just thought I'd take you to what Mr. Justice Bingham said before that, when he was talking about the law.
Sorry, we're looking at Mr. Justice Bingham.
This is Mr. Justice Bingham, because this is
not the Court of Appeal.
Not the Court of Appeal. No, I think.
Oh yes, I saw it. This is Bingham. Yeah.
This passage about the parties being masters of the contractual fate was in Mr. Justice Bingham's judgment. But previous to that, he said, page 269, the general principles to be applied in deciding the issue in this case, this is about whether there was a contract, are not, I think, open to much doubt. The court's task is to review what the parties said and did, and from that material to infer what the parties' objective intentions as expressed to each other were to enter into a mutually binding contract. The court is not, of course, concerned with what the parties may subjectively have intended. So that's the context in which he made these remarks about the parties being the masters of a contractual fate. It's in that sense. And then he goes on to cite Lord Denning. In contracts, you don't look at the actual intent of a man's mind, you look at what he said and did. A contract is formed when there is to all outward appearances a contract. A man cannot get out of a contract by saying, I did not intend to contract. If by his words he had done so, his intention is to be found only in the outward expression which his letters convey. They show a concluded contract, that's enough. So we're looking at not what they privately intended, but what what they said and did. But what in this case the employer did was not to make an offer to the contractor, a contractual offer to carry out work. What they did was issue an instruction. All the parties at the time, and even to this day, I think, believe was a valid instruction to build the building in those terms for that price.
Well, what they purported to do was to perform the contract.
But, one should say that, or to perform it a particular way.
Yes, they purported to perform the contract by exercising rights under Clause 12.1.
But exercising rights
if they were right, they've performed the contract, and that's the end of the matter.
Yeah.
If they're wrong, and they couldn't utilise Clause 12.1 for that purpose, then they've issued an invalid instruction, but that instruction has been accepted by the... and they've also paid money. So are you seriously suggesting there isn't then a contract? Because I thought that the whole point about the new contract argument was that if there was any contract, it was a contract on fresh terms, which was that a new building would be built and a certain amount of money would be paid for it.
Well, that is what, if there is a contract, that's what we would say, yes.
Yeah.
Yes. But to be a contractual variation, there would have to be a contract to vary, i.e. an agreement. What I'm saying is, if someone believes in their power and they instruct someone to do something, you cannot deduce from the fact that the person did it, or at least took the payment, that they were agreeing in a contractual sense to do it. Putting it another way, supposing you can't tell whether if they had the choice or not, they would have agreed. So you can't say to somebody, you entered into you did something because you thought you were obliged to do it because of could be a statutory power, whatever. You did it, therefore you must be taken, even if the power is invalid, to have agreed to do it. And that can't be right. If you're being compelled to do something, you cannot. It can't be spelt out of that you've agreed to do it. When you say they accepted the money, but that's again on the basis that they thought that they were obliged to. I'm looking at this objectively. I mean, in reality, of course, no doubt the parties didn't care because they're in the same group. But we have to decide all these things looking at objectively looking at what they did. So if a party says to another, you're obliged to build this building for 58 million, I'm going to pay it to you now, and he pays it to them, and the party keeps it, you cannot spell out of that the party who's been told that, assuming that that's what they...
Well, what about the wording of the invoice, though?
Well, the invoice is...
Payment of construction sums due under contract between us, dated the 17th of February 2006, and pursuant to employer's change order 2, in full and final settlement. Yeah, but that shows the reference to change order 2. This is being paid on the basis that there has been a valid variation of the contract. That's the basis on which it's paid.
Variation pursuant to clause 12.
Pursuant to clause 12, yeah. I mean, it refers to the change order. That's what it's paid.
It produces some fairly startling results again, because on that analysis, the payment has been made under a misapprehension. Let's suppose then that the contractor decides not to do the fit out. The employer, yes, might be able to make a claim for money hadn't received to get their price back. But on what basis could they compel the contractor to carry out the work, if you're right?
You mean if nothing else happened as it did in fact? Yeah. If the SDA hadn't been entered into?
Yes.
Then, yes. Well, well, there's a more difficult, more obvious problem with that, which is that the instruction doesn't refer to the fit out in this case at all.
Well, even the construction. Let's suppose they pay the 54 million or whatever it is up front, everybody's labouring under the misapprehension that this is a valid variation. Turns out they're wrong about that. I take the point that you can't infer that they would have accepted to do the work if it had been offered to them as a new contract. Or,
Yes. Yeah.
But if there is no contractual arrangement, then surely the consequence of that is that the employer, let's suppose the scales fell from everybody's eyes after the money had been paid over, and there was no SDA, could have compelled the contractor to do the work.
Well, the employer would be able to recover the money.
Yes, as money hadn't received.
Yeah, but he wouldn't be able to compel it because he hadn't properly exercised the power. There's nothing unusual about that. They would then be free, of course, to contract it any way they wish, which is what they actually did. You do have to remember.
By entering into the SDA, you mean?
But they entered in the SDA 3 days later. Obviously, all parties knew they were going to enter into the SDA. I mean, it must have been in contemplation of everyone that was going to happen. It must have been drafted by this stage. It's a very complicated document. So by the 1st of April, the SDA must have been drafted. It wasn't signed till the 4th, but I mean, everyone knew that was going to happen. So there's no commercial problem in this case. If there was another case where this happened on an unlikely circumstance where somebody did this, then leaving aside the tax point, because obviously we're assuming you're not interested in tax, the parties could simply agree whatever they like.
Well,
But the employer could not insist on the work that he had invalidly instructed.
Yeah.
Yeah. So there wouldn't be any problem in this, even if this unlikely occurrence arose in a genuine commercial case. So we say that's simply impossible, and then the construction of the building cannot be relevant to this because we know that there already was a contractual obligation by the time they constructed the building under the SDA to build it. So you can hardly say that building it under that contract somehow indicated that you were accepting an earlier contract, because already there was a contract in place, and that was the one under which they built it. What we don't know is whether what they did was any way in accordance with the purported variation, because again the problem is we don't have the actual employer's requirements. We can guess that it was broadly maybe in line with it, but it's very possible that it wasn't. The details of what they built were not in line with the employer's requirements in the draft. Those had been refined and changed by the time we got to March 2012, which is nearly a year later.
But if they've been refined and changed, you'd expect there to be other documents reflecting the refinements and the changes passing between the employer and the contractor.
Yeah, well, maybe there were. We don't know. I mean,
What
presumably
we've
would have
got at
been.
the moment is what the contractor told the subcontractor some months later, from which it could be potentially inferred that it's, as you say, broadly in line with what they were told further up the chain. May well be more detail to it, but even if there's more detail to it, you'd expect there to be some further documentation showing that detail.
Yeah, you mean some negotiation between them?
Yes.
Yeah, no doubt there probably was, but I don't think we've got any of that. I mean, another interesting point is when you look at the SDA, as you've seen, there's a lot of things scheduled to it, including the change order, but not the draft employer's requirements referred to. Seems very strange that even at that point, which is 3 days after the change order, they didn't think it was particularly important to include the draft employer's requirements as one of the documents in the SDA. I don't know whether they'd lost it at that stage or not, but hard to tell.
Yeah.
But that just was some indication that it wasn't particularly regarded as particularly important. Because of course the parties were then going to work up what they were going to send out to the subcontractors, which they did in 2012. The whole process, as we've seen, was carried out under the framework of the SDA, which provided for how it's to be done. So it also would seem, I mean, this argument that with the contract, the offer was accepted by the building works would also seem to create a timing problem. I mean, when was this contract made? I mean, you would say, orthodox view, you would say it was made when they accepted the offer, presumably. That raises a difficult question as to how the expenditure could be incurred under that contract, which wasn't made until months, possibly a year later, after the date. Just doesn't. Even if you could say, well, that was an acceptance of the offer, it just seems that timing is wrong. So anyway, that's our primary first point. Second point is, anyway, if you did spell a contract out of this, it would be a new contract because it's inconsistent, we would say, with the root of the original contract. It provided for and for that purpose, you do have to look at the original contract, subject to the election for works option 1, because you don't ever get into clause 12 or variations or anything until you've got a works option chosen, and they chose works option 1. So a comparison has to be made, we would submit, between works option 1 and the new contract, or the varied contract. And we would say it is inconsistent because it's I think it was said in opening, it's a different building, completely different price, much lower price, and a different site from works option 1. I mean, works option 1, in fact, was on a site that was, as I think you know, was built on, and indeed was probably owned by someone else at the time.
Just help me on this, would you? What, if anything, is the effect of change order 1, which we were shown this morning, which is headed work options 1 and 3. It requires the building of a data centre, 4,262 square metres for a particular contract sum. Goes on to say the further change orders may be issued in respect of buildings within work option 3, not 1, or otherwise. And then the next page, box 1, variation request, add, omit and substitute as necessary to the employer's requirement for works option 1, so as to provide to Shell & Core of 1 data centre totalling 10,217 square metres. That's about a quarter of the... Oh no, it's more than that. So it's more than the original. So what does that do to the developer's ability thereafter to select works option 1 under the contract?
Yes, well, the only way that it could have maintained it is if it was somehow capable of varying the contract to allow further works options to be selected.
But it
could
change order 2 purported to select works option 1 again.
Yes, I know. It is quite difficult to
But
understand.
that seems to have been already selected.
Yes.
You can go for option 1 and option 3 as a result of variation number 2.
Which is what they did, I think.
Which is what they say that they wanted to do, and that makes sense in connection with change order number 1, which refers to buildings within works options 3 or otherwise. What confused me when I looked at these documents first this morning is the document behind tab 3, which appears to be something to do with works option 3, with instructions under clause 23A of the contract to build something under options 3 for an office block.
Yes.
I don't know whether that was abandoned or what happened with that, or what was this doing here, but this is all to do with works option 3. And
Yes, I'm afraid I can't help you on that. I understand there were many documents before the Upper Tribunal. There were lots and lots of files, and they were in a bit of a higgledy-piggledy state. I understand that this document was amongst those documents, as was workshop, the final one, and possibly the invoice, although we're not very sure about that. But it was never, as I understand it, was never referred to or looked at by the Upper Tribunal. I mean, I agree, my lord, it does look as though they've performed the contract on the face of it, but under the first one. And certainly, if they haven't, then they performed it under the second one, on the DC2, because of DC3, of course, chose the works option 1 again. So it really doesn't make much sense, but I think it's fair to say this wasn't looked into before the Upper Tribunal. And yes, I don't know what works option 3 is, or whether it was built or what.
Well, I think it potentially makes a difference. I'm just trying to find where I put the map at the moment. Just generally because of where the sites are. I think it's just a little bit of
Right, well,
that. Because DC1 is built on Site C.
yeah,
And everything else is on Site A. The DC2 and DC3 are on
DC3
Site
is on Site B, or nearly.
Well, yeah, a large part of it's on Site B.
Yeah.
But DC2 is definitely on Site A, isn't it?
Yes, well, DC3 is on Site A as well, because Site A
Embraces
Site A.
Site B.
Site B, yeah.
But as I recall the options, thank you, only one of the options allowed for building on Site C.
Yes,
Was that option 1?
I think that's right. That's option 1, yes.
All right, so you've built a building which has taken up virtually the whole of Site C, which is what option 1
Yes.
says. How then can you, again, exercise option 1 so as to build something in a different part of the site? I'm a bit puzzled.
I think it can only be on the basis that they viewed choosing option 1 as something that didn't have any meaning, and it just didn't have any existence for any time before they'd varied it to build something else on some other side. That's the only way I can make any sense of this. I really don't. I'm afraid. I'm sorry. I can't assist, but it doesn't. I've puzzled about this. It doesn't really make much sense to me.
Yeah.
But we do know that they did have a notice to proceed on works option 1. So contractually, that's the only thing that they've got in relation to both DC2 and DC3. Oh, and DC1, of course. Yes, I mean, it is interesting to note that the change order in relation to DC1 does refer to the fit-out, although it says that will be subject to a further instruction, whereas the DC2 doesn't refer to it. For completeness, we would submit that the reference to commissioning is not a reference to the fit-out, but it's a reference to commissioning the building works of Shell and Co. You'll see there's the same reference in DC1 to commissioning the building works. The commissioning, I'm told by those who know, means getting together your contractors and whatever to build something.
Yeah.
Now, so we say it goes to the root of the contract. In my submission, my learned friend was muddling up in his submissions a statutory question, which has to be asked in this case, which requires an analysis of the legal position. And he's muddling up that and the commercial dealings between parties, where the strict legal analysis does not necessarily matter. What does matter is what the parties have agreed. Now, Blue Circle was an example of a case where it did matter between the parties. What happened in that case was that there was a dredging contract between two parties, And then at roughly the same time, they also agreed a contract to use the sludge or whatever that they were dredging.
Build an island.
To build an island, exactly. Well, you may be familiar with this case. So the problem was that, I'll call it contract one. Contract one had an arbitration clause for the dredging. Contract two for the island didn't have an arbitration clause. And I think it was agreed, I think you couldn't read one in to the contract. The problem then arose about contract two, because the island didn't work very well and sunk and everything, all sorts of problems with it. So there was proceedings under contract two, and the question was whether they could go to arbitration. And so the issue for the Court of Appeal was whether contract two was actually simply a varied version of contract one, so it was the same as contract one, or at least had the terms of the arbitration clause in it, or whether it was a separate contract. And despite the fact there were two agreements in that case, they applied a test as to whether the employer could have issued a valid instruction under what was the equivalent of clause 12, although it was quite different terms in that time. I think it was clause 51 of some earlier civil engineering contract. So the Court of Appeal said, if in this case we'll decide on the basis, if they could have issued an instruction, then we'll treat the two contracts as one. Although they didn't actually issue an instruction in that case, but that would be if they could have done that, issued an instruction to do the work in contract two. But the Court of Appeal decided they couldn't have. It was not sufficiently. It was too great a difference. So they couldn't have issued an instruction under the equivalent clause 12 in those days to do the second lot of work, and therefore they were treated. They said there were two separate contracts. That's what Blue Circle was about. So that's where you got this idea that, as one of their friends said, that you have to decide whether they've got the power to do it. But of course, in this case, that simply asks the question, which is, do they have the power? The provision in question in Blue Circle was actually very different from clause 12, although it was a similar kind of variation provision. But it wasn't in the same terms at all as clause 12. In fact, if you want to look at Blue Circle, you will find that it doesn't actually set out the clause in the case. It's obviously a very well-known clause amongst construction lawyers at that time. We have found it. It's quite easy actually to find on the internet. So if you wanted, we could provide you with a version of the version. It's very short, but it may not be relevant. But the point was, it didn't have this kind of wording that we have in this clause. It wasn't talking about employers' requirements and things like that. It's totally different. And they were asking a much more general question as to whether this was too great a change to be something that you could instruct them to do. Just looking at the cases, my learned friend appears to suggest that there is some difference of substance between what Viscount Haldane said in Morrison Barron and what the rest of them said. Now, I would say my first submission is that there isn't any difference. You're really putting too much weight on a very few words, literally 2 words, I think, in one sentence in a speech. It's quite clear from all the rest of the speech that Viscount Haldane is really following the same approach as the others. But even if he wasn't, he would be in a minority of 1. It then being suggested that Lord Sumption was somehow adopting this different approach in Plevin. Well, my submission, that can't be right. He did cite that passage, probably because he just thought that was a convenient passage to cite. There's no suggestion that Lord Sumption was changing the law or developing the law in that area. He was applying the conventional approach. He may have been surprised to be told that there was some difference between what Viscount Haldane said and what the rest of them said. But it certainly wasn't an issue in the case. The change in Plevin was actually pretty small. It was to extend the CFA to appeals, but also to change it changed the success fee, but we've looked at another case in the litigation, and apparently the change was from 100% to 96%. So it wasn't a very significant change. And I think that's what Lord Sumption was referring to. He was simply saying this is just not, we're not in the ball game of change is big enough. But he wasn't suggesting, I would submit, he wasn't saying that the parties expressed, the parties expressly say this is not a variation or whatever in the contract, that is conclusive. I think what he was probably saying was, in a case where it's not a fundamental change, then the parties can conclude it by one way or another. Because of course the parties could say, we're bringing this contract to an end and entering into a new one. And that would be a valid thing for parties to do in the contract. They could say that. Alternatively, they could say, we're not bringing the contract to an end, this is just a variation. And I think what Lord Sumption was saying really was, in these few words in 11, was just, in a case where it's not a fundamental change, then the parties can conclude it one way or another by what they say. Of course, we're not even in that ballpark here, because we don't have a express contractual term saying this is a variation, this is not a variation. But I think the generally orthodox position in the authorities is that you cannot conclude the question by simply labelling it in the contract. And can I then end this by just looking at what the Upper Tribunal decided on this and dealing with the point that they've made findings of fact. And this is what they said in 108. But I think you need to go back to understand this to 106. So 106, they say, this is after they've dealt with the authorities and said what they thought that they decided, which was not what we said. They then say, applying a test based on the parties' intentions, we have no doubt they intended the change orders only to vary the contract, not to rescind it. This case is far from the type of case referred to by Lord Justice Toulson and Samuel, where the parties do not turn their minds to the somewhat legalistic question of whether or not a variation is intended to rescind the original agreement. Viewed objectively, the parties to the Golden Contract clearly intended that contract to preserve the entitlement for someone to claim EZAs on construction expenditure on the site. Now, what this is suggesting is that the way that you construe and interpret contracts and whether and their effect depends upon whether the parties have beforehand sat down and thought about the issue to any extent. So if they, in a tax planning context, if they've thought down and said, well, we do need this to be a variation rather than a new contract, don't we? Then that is irrelevant to the construction, to the decision as to whether it is a new contract or not. And they're suggesting that that's what Lord Justice Toulson was saying in Wadlow and Samuel. And in my submission, that's certainly not what Lord Justice Toulson was saying. He wasn't suggesting that there's a different, the rule applies differently where the parties have turned their mind to the question. So, viewed objectively, I think what he did say something along the lines of, well, this is a very recondite question.
Sterile.
He said it was sterile, but yeah, because people don't think in this way. Which is probably right, but it doesn't follow that if they do think in this way, it makes a difference. Viewed objectively, the parties to the Golden Contract clearly intended that contract to preserve the entitlement for someone to claim EZAs on construction expenditure on the site. Well, in the sense that they wanted it to work, yeah, I'm sure that's right. The change orders, but irrelevant, we would say. The change orders were similarly intended to result in a building being constructed that was somewhat different from those provided for in the Golden Contract, but for EZAs nevertheless still to be available on the cost of construction. Again, that's what they desire the consequence to be. Mr. Williamson QC was correct to submit the party's common desire to ensure EZAs would be available to the purchaser of the building, ultimately constructed as strong evidence of a common intention the change orders would not result in rescission. Well, I think even if you substitute something for desire, that's still, we would submit, wrong. Even if it may be evidence of their intention, but it's not the intention that contract law is interested in. This is where there's I think, problem with the ambiguity of the use of the word intention. That has been pointed out in some other cases in the context of the construction of contracts. In fact, it's some of the cases that are cited in my Lord's book, where various judges have...
Yeah, well, there's Inland Revenue in Raphael from 1935.
Yes,
that point
I think there's more recent authority as well cited in that passage, where they say, I think it may be Mr. Justice Voss, but anyway, someone who said they think the problem here is the problem, misunderstanding about what's meant by intention. People
well, 106 focuses on what the parties desired the intent, the consequence to be.
Yes, exactly. Exactly. And then they say, Mr. Cosman argued that this reasoning results in primacy being given to the party's subjective intentions. Since neither the Golden Contract change orders refer to 2001 or tax benefits, we do not agree at all material times they were under common control. I'm not sure the relevance of that. And the Golden Contract entered as part of arrangements designed to ensure EZAs could still be claimed. Well, that's true, but irrelevant, we would say. The expectation they would continue was not an express subjective wish. On the contrary, it also informed the common approach to changes of it. Well, if what they're saying there is, this is why they entered into these transactions, to get the tax benefits, well, that would be true, but that doesn't tell you anything about what the nature of the transactions was. Everyone who enters into arrangements to get tax benefits wants to get the tax benefits, and that's why they enter into the arrangements. But you can't say that means that that whatever they've done must be that which is most beneficial to them. And then they say, in those circumstances, the desire for construction expenditure to qualify for EZAs was a common goal, is directly relevant to the objective ascertainment of their intentions. Well, again, that's the wrong type of intentions. That's what they are broadly intending or hoping to achieve, but not the intentions that are relevant in deciding the terms of a contract, or whether there's a new contract, or whether a contract's been rescinded or not. And that's the case even though they didn't refer to the EZAs. But in my submission, it wouldn't have mattered whether they referred to the EZAs or not in the contract. Even if they'd said in the contract, we're desiring to obtain these EZAs and we're entering into these contracts in order to obtain the EZAs, that wouldn't affect the legal analysis of what they had done. If what they then did was to, well, either nothing or change the contracts in such a way that there's a new contract. In fact, they express a general wish, or they express the reason why they're entering into the contracts. Can't affect that. As I said, I think yesterday, you can of course figure a case where something like that, an expression in the contract, in a recital, could be relevant in construing a particular term in the contract if it was ambiguous and you needed something to help you. But it's not relevant to this. It wouldn't be relevant. In any event, it doesn't exist in this case. So we say that they've already decided, before they get to paragraph 108, they've decided that the common intention of the party, the relevant common intention was not to change not to have a new contract or a rescission. And what they were then doing was asking the question, some way, whether these factors that they set out in 108 were inconsistent with this common intention that they already found. But the problem is it's the wrong common intention they found. So they're asking the wrong question in 108. They should have been asking the question, they should have been looking at the factors in 108 and deciding whether what that demonstrated as to the common intention, objectively assessed. But that's not what they did. And if they had done that and produced a reasoned argument, a result, then of course that would have been, you could say, well, they've come to an evaluation, as long as it's not an unreasonable one, where they've come to a conclusion they couldn't have come to, then that would be fine. But they've simply not asked the correct question here. They are focusing on the wrong type of intention. That's what we basically say.
Yeah.
So I think those are all my submissions in reply.
I think I'm entitled to a brief reply on clause 12.
Clause 12, yes, indeed,
Yes.
Mr. Williamson.
Which didn't loom large in Malone and Friends submissions, to be fair. There were three points that he made that I wish to respond to, and with your indulgence, there are one matter on the authorities and one matter of housekeeping, which I should deal with. First of all, Malone and Friends' principal point on clause 12 was to say that the contract sum cannot be altered by a change in instruction given under that clause. That is, unsurprisingly, another new point which was not raised before the Upper Tribunal. But just to see how that would work, if we could look at the bespoke amendments, it is in fact clause 12.3a. I think there was reference to clause 24, but I think this is the right one. It's page 51. So we have a situation under clause 12.3a1 that there's an instruction given which may require an adjustment to the contract sum and or delay the date of completion. Then the contractor has to give notice and give further information. Then 12.3a2, following receipt of those documents, the parties are to endeavour to agree the estimates, and any agreement so reached and evidence in writing shall be binding upon the parties. Now, and then at 12.3a3, if agreement can't be reached within 5 working days, then instruction can still be given, in which case the provision of clauses 12.4, etc., etc., apply. Now, my submission is that it is to be, that the point wasn't gone into in evidence for the reason that I've mentioned, but it can reasonably be inferred that the parties had in fact reached agreement on the 54 million within 5 working days of receipt of the instruction, of the estimates, because, as my Lord Justice Lewison pointed out on another aspect, the invoice was raised by reference to change order 2 and was paid. So it's perfectly open to the parties under this clause to agree the financial consequences of a variation, a change under clause 12. If they do, then that is binding upon the parties, and the contract sum, going back to Malone Friend's point about clause 13, which is on page tab 1, page 17, the contract sum is then being adjusted or altered in accordance with the express provisions of the conditions. So Malone Friend also submitted that this was a standard form, and therefore the court had to construe it on the basis that it was to be used by many thousands of parties. That is true up to a point, but of course this is a JCT form which has been very heavily amended, and so it is not the JCT form which is used by this particular contract is not one which would be used by many parties. And then finally, Article 10, which is, I hope that my lords and my lady may have moved into the supplementary bundle. So that should be behind page 39.
Yes.
That article, again, which is quite a common type of article to find in the building contract, only applies where there is a discrepancy or conflict within the suite of contract documents. And my learned friend didn't actually identify what that conflict or discrepancy might be, because on our analysis, the fourth ranking document, the employer's requirements, are being changed by the Clause 12 instruction, and the effects of that are then valued in accordance with the contract under Clause 12 as amended. So there is no conflict. So that's all I wanted to say about Clause 12. Could I just very briefly look at Pagnon, which I alluded to but didn't actually cite in my submissions. That is in Authorities Bundle A, tab 14, page 270.
Yeah.
My learned friend took you to the passage on page 269, but just to contextualise that, we're told at column 1 on page 270, the famous phrase, the parties is to be regarded as masters of their contractual fate, it is their intentions which matter, and to which the court must strive to give effect. In this endeavour, help is to be granted, again from Lord Denning. And Lord Denning simply says, well, we don't want to be too bothered about offer and acceptance. We look at all the documents passing between the parties, and I would add any relevant conduct or conversations. And in my submission, the point my learned friend was just making about intention really proves too much, because if one ignores the taxation aspects entirely, then what the parties were doing in April 2011 was simply seeking to agree a commercial variation, I'm using that term loosely, of their arrangements. And they certainly would never have, could not be thought to have been intending to rescind or
were they seeking to agree a commercial variation? That's the whole point. They were seeking, surely, to implement a commercial variation by performing the contract. Maybe, with respect, a slightly better point for you, because if they were trying, mistakenly, but they were trying to implement the contract, it's a bit difficult to infer that they had an intention to rescind it.
Yes, well, I hoped that I had, my lady, I accept the point that I think I had attempted to cover that ground this morning, but I hope that I had done so. Then, could I just mention a couple of matters of housekeeping? My lady asked in the course of my submissions this morning when DC1 was completed. I'm not sure there's anything in the papers about this, but I'm told it was completed to shell and core in 2011, and the fit out was partially completed later. But I'm not able to offer.
Do we have a month?
Yes, I'm reminded by Mr. Jones. Yes. Well, paragraph 8 of the judgment refers to that date of 2011. but it doesn't attach a month to it, and I don't have a month to attach to it. Secondly, so far as the 3 contemporaneous documents I handed up this morning are concerned, those were all, I'm instructed, in the tribunal, at the bundle before the Upper Tribunal. And as regards the site plan, we will endeavour to provide a more legible plan. Which
I'm also conscious that I still haven't had the HMRC's supplemental argument on clause 12,
Right,
but that may not matter.
my lord, that I think is not my burden.
No, all right. You just mentioned housekeeping.
Yes, I was dealing with sort of cleaning my house.
I told my letter junior that when Clark requested the skeletons in soft form.
Oh, I see.
You got all 3.
Did I? All right. Well, in that case, I can look at it.
I'm told that.
Online. All right.
And my lord, absolutely finally, in the course of Malone Friends' submissions, I think it was just before lunch, my Lord Justice Lewison debated with him the interplay between these proceedings and the judicial review proceedings, and I had already made a point about that, but as a separate point, the submission that Malone Friend was making at that stage was to the effect that Section 298 required the parties seeking relief to specify the building, the site, etc. in the contract, i.e. that there were additional requirements over and above those which we say arise under Section 298. And our submission is that if those points had been raised by HMRC in these proceedings at an earlier stage, then we would certainly have considered judicial review proceedings in relation to that. There are exchanges which go to that in the judgment at paragraphs 320 to 322. Yes. And finally, so far as housekeeping is concerned, so far as we're concerned, there is no objection to the skeleton arguments being provided to Pinson Masons.
Yeah. Oh, I forgot to ask you, Mr. Hewitt, is there any objection from HMRC?
I'm sorry to say, it seems that the revenues policy, we don't object, but the revenues policy seems to be to ask for a court order.
Is it because of taxpayer confidentiality?
I don't know what exactly.
Well, I see somebody nodding behind you.
Yes,
Well,
I think that may be the reason.
perhaps the taxpayer will agree to HMRC releasing its skeleton arguments to Pinson Masons. Right, nods all round,
Yep,
so
okay.
that's all right.
Thank you, my lord.
Good afternoon.
Yes, Miss Shaw.
Good afternoon, my lord.
So now we're on to your appeal.
Yes, so I'm going to address you on the LLP's appeal,
Yeah.
which concerns the third of the issues, which was before the Upper Tribunal, namely as to the question of whether the whole of the capital sums paid by the LLPs were paid for the relevant interest
Yeah.
within the meaning of Section 296.
All or part. Yeah.
Or whether some part were paid for
Something
a
else.
variety of items which HMRC had identified. Now, I think we've already looked briefly at the requirements of Section 296, so I wasn't going to take you back to that provision unless you'd like to see it. For present purposes, the relevant requirement is that the purchaser pays a capital sum for the relevant interest, being the interest to which the developer was entitled at the time of the expenditure. Now, before the Upper Tribunal, it was common ground that where a developer prepays the whole of the construction costs and then assigns the benefit of its rights under that contract to an investor, then the capital sum paid by the investor for the assignment of those rights is capable of satisfying the requirements of Section 296. The issue was whether the whole of the price paid by the LLPs was paid for the relevant interest. Now, that wasn't a simple yes or no question. The issue is set out in paragraph 29 of the Upper Tribunal's decision. And you can see there that it involved consideration of a number of specific items which had been identified by the revenue as items for which the price was said to have been paid, or which affected the analysis as to the amount said to have been paid for the relevant interest.
Yeah.
The key paragraphs in the Upper Tribunal's reasoning on this issue begin at paragraph 238, and its analysis can be briefly summarised as follows. So in 238 and 239, the Tribunal finds that it was apparent from the contracts and from the substance of the matter that the LLPs acquired additional rights and benefits alongside the relevant interest. Then at paragraph 240, the Upper Tribunal describes what those rights and benefits are, and it describes them as one, support for the expenses, so expenses support arrangements or ESAs, then rental support arrangements or RSAs, thirdly capital repayment support arrangements or CRSAs, and then fourthly the discharge of the arranger's fee. The Upper Tribunal then went on to consider whether those rights and benefits were properly to be characterised as ancillary to the relevant interest, and therefore not things for which the LLP should be taken to have paid, or whether they were properly to be characterised as separate and distinct assets for which part of the price should be regarded as having been paid. And as to that, the Upper Tribunal concludes at 250 to 253, as regards the rental support arrangements, it regarded those as analogous to a warranty of value and therefore ancillary to the relevant interest. Although the point in relation to the RSAs was, as the Tribunal notes, strictly academic in light of its conclusion on the JR.
Yeah.
Then as regards the ESAs, those are addressed at 253 to 254, and the Tribunal did not consider that those could be regarded as analogous to a warranty of value, and accordingly it was said they were not ancillary to the relevant interest, but rather constituted a separate asset for the purposes of section 296, again for which part of the price was paid. But again, that issue was strictly academic in light of the conclusion on the JR. The CRSAs are addressed in paragraphs 255 to 258, and in relation to those, the Tribunal also concluded that they could not properly be regarded as analogous to a warranty of value, and therefore should be treated as separate assets for which part of the price was paid. And then finally, at 259 to 263, the Tribunal addresses the arranger's fee, which again it said was properly to be regarded as a separate asset for which part of the price was paid. So the result of all of that at paragraph 286 was that the Upper Tribunal considered that it was necessary to carry out an apportionment in order to determine the part of the price that was paid for each of those components, namely the relevant interest on the one hand, and then the ESAs, the CRSAs, and the arranger's fee on the other.
Yes.
And that question of apportionment was then the subject of its second decision, and in very general terms, the upshot of that was that the LLPs were entitled to EZAs on roughly half the price that they had paid.
Yeah.
So the LLPs appeal against those decisions on three grounds. First, we say that it wasn't open to the Upper Tribunal to decide the appeal on the basis that part of the price was paid for for what it had termed the CRSAs. Secondly, we say that the Upper Tribunal's conclusion that part of the price was paid for the ESAs, CRSAs, and arranger's fee is predicated on a misinterpretation of the requirements of Section 296 and a mischaracterisation as to the nature of those elements. And then thirdly, we say that the Upper Tribunal erred in its approach to the apportionment issue. So, starting with ground one, the first ground is that it wasn't properly open to the Upper Tribunal to determine that part of the price was paid for the CRSAs, and that is because this wasn't an argument which had been raised by the revenue at any point in the evolution of its case, but rather was something which had been raised by the tribunal itself and raised in an unparticularised way and at an advanced stage in the hearing. And we say that as a result of that, the way in which it was raised, the LLPs have been materially and unfairly prejudiced. So the simple and no doubt uncontroversial proposition on which we base this ground of appeal is that whilst it is in principle open to the parties, or indeed the tribunal of its own motion, to introduce new arguments during the course of the proceedings, that is subject always to the requirements of fairness and proper case management.
Yeah.
And the authority for that proposition is the decision of the Supreme Court in Tower and Cashback, which is in volume B, behind tab 30. So the procedural issue in this case was whether it was open to the revenue to reinstate at the hearing before the FTT an argument which it had previously abandoned in the course of the correspondence. In other words, prior to the issue of the closure notice, which was the matter under appeal in that case.
What, you say it was expressly abandoned in correspondence?
It had been abandoned in correspondence, yes.
Right, because the closure notice simply says you're not entitled to anything.
No, I'm talking about the closure notice in Tower M.
Oh, I see.
There was an issue. There was
I'm
an
sorry, I thought
argument
you meant in this case.
No, in this case, the closure notice says you don't get any allowances.
Quite.
It does give some. There is some specificity to it, but it essentially says you don't get anything. In Tower M, prior to the issue of the closure notice, there had been an argument that had been debated between the parties, and the revenue said we're no longer running that case.
Right.
And then they turned up at the hearing and said we'd like to run that point now. So,
Right.
so that was the procedural issue that arose in Tower M. And in paragraph 15...
Sorry, we're looking at Tower and Cashback.
We are, yes,
Which
sorry.
bundle?
It's page 585. Yes, please. I just
Bundle
wanted to...
B.
Bundle B.
Thank you. 585.
585. So in paragraph 15 here, Lord Walker is citing passages from the decision of Mr. Justice Henderson below, and he sets out a paragraph 115 from his judgment, which reads, there's a venerable principle of tax law to the general effect that there is a public interest in taxpayers paying the correct amount of tax, and it's one of the duties of the commissioners, that's the special commissioners, in exercise of their statutory functions, to have regard to that public interest. For present purposes, however, it's enough to say that the principle still has at least some residual vitality in the context of Section 50. That's a reference to the TMA, which gives the tribunal power to increase or decrease an assessment. And if the commissioners are to fulfil their statutory duty under that section, they must, in my judgment, be free in principle to entertain legal arguments which played no part in reaching the conclusions set out in the closure notice, subject always to the requirements of fairness and proper case management, and such fresh arguments may be advanced by either side or may be introduced by the commissioners on their own initiative. And then that sort of reasoning is echoed in over the page in Lord Justice Moses's judgment set out at the top of the page, just above the whole bunch, where he says, any evidence or any legal argument relevant to the subject matter may be entertained by the Special Commissioner, subject only to his obligation to ensure a fair hearing. And then at the bottom of the page is an extract from Dr. Avery Jones's decision in the Darcy case, which is set out at the top of page 587. And he says, it seems to me inherent in the appeal system that the tribunal must form its own view on the law without being restricted to what the revenue state in their conclusion or the taxpayer states in the notice of appeal. It follows that either party can, and in practice frequently does, change their legal arguments. Clearly, any such change of argument must not ambush the taxpayer, and it's the job of the commissioners hearing the appeal to prevent this by case management. So the point is that there's not carte blanche to introduce whatever points you want to run at any stage in the proceedings. The point is, it is in principle open to the parties, or indeed the tribunal itself, to introduce new arguments, but that is always subject to the requirement of fairness.
Yes.
And for your note, those principles from Tower M are then summarised by the Court of Appeal in the Fidex case.
Yeah.
And that, for your note, is volume C, tab 34.
That's Lord Justice Kitchen.
It is, yeah, it's paragraph 45. And our complaint, in a nutshell, in this case, is that the manner in which the issue of the CRSAs was introduced did give rise to material unfairness, and for that reason, we say it should not have been raised. Now, it's worth turning up the Upper Tribunal's response to our complaint, which can be found in its decision on our application for permission to appeal, and that is in the core bundle behind tab 12. And it's paragraph 18 on page 314. And at line 10 there, the Upper Tribunal says, the LLPs are correct to say that the Tribunal's description of those additional assets set out in paragraph 240 is somewhat different from the description that HMRC had advanced set out in paragraph 218. However, that does not mean that the Tribunal determined the appeals on the basis of an argument not raised by either party. The Tribunal's description was derived from relevant aspects of the contractual documents which had all been at the heart of HMRC's submissions. There was no procedural unfairness in the Tribunal adopting a different description of those additional assets from that used by HMRC, particularly given that 1, the Tribunal shared with Council during the hearing its developing views on how those additional assets should be described, and 2, the LLPs had the opportunity to adduce further evidence, including expert evidence, and to make submissions at the second hearing as to the amount of the purchase price, if any, that should be attributed to those additional assets.
Yes.
So, in the first instance, the Upper Tribunal denies that its conclusion on the CRSAs amounts to a new argument. It says instead it was simply a different description of the additional assets for which the price was paid. Now, as to that, we say that the difference between the revenues case and the conclusion which the Upper Tribunal reached was not merely one of description. The Upper Tribunal's analysis and the revenues case were materially different in substance. So in 213 to 218 of the decision, the Upper Tribunal records the evolution of the revenues case. And you can see in those paragraphs the various iterations of what it was that the revenue suggested part of the price had been paid for. And at no point in those various iterations was it suggested by the revenue that part of the price had been paid for anything resembling the CRSAs as described by the tribunal in paragraph 240. The closest that the revenue's case ever got to the CRSAs, and even then this was a point only raised by the revenue in their closing, was that part of the price equal to the amount of the cash collateral had not been paid for the relevant interest because it was, in essence, circular funding. So the revenue below, this is set out in paragraph 247 of the decision, and essentially the revenue's argument in relation to the cash collateral was a sort of Tower M cashback type argument. The money goes round in a loop, and therefore you haven't incurred it. It's not expenditure incurred on the particular assets. And we say that that is a very different argument to the conclusion reached by the Upper Tribunal.
Well, if you go back to 214 for a moment,
Yeah.
I mean, that's in the statement of case. And what HMRC is saying in that is that to the extent that the capital sum was attributable to payments made for items which were distinct from the relevant interest, you don't get relief. And what their positive case, so to speak, is that only that part of the capital sum which represented expenditure required to complete the construction of the building and reasonable profits and charges related to its construction attracts relief. So that's the pleaded case that you were having to meet.
Yes, and if you go on in 215, it carries on. They went on to plead that the portion of the price which was not paid for the relevant interest related to other charges in particular but not limited to 3 items: proportion of the capital sum required to pay the yearly sum, secondly, the fit-out costs, and thirdly, the price attributable to the land.
Yeah.
So that was the revenue's positive case.
Not limited to, yes.
Yeah, well, we had some debate about what that meant in relation to other arguments which emerged during the course of the hearing. But the simple point is, it was at no point suggested by the revenue that what we had paid for were rights and benefits described by the Upper Tribunal in paragraph 240 as capital repayment support arrangements.
Yeah.
In fact, the point was put to the revenue, is this what you're saying? And they said no. So we say that the Upper Tribunal's conclusion is materially different to the case that we came to the tribunal to meet. Secondly, and in any event, the Upper Tribunal contends that there was no procedural unfairness here to the LLPs because it had shared its developing views as to how those additional rights should be described during the course of the hearing. Now, as to that, we say insofar as the matter was raised at all by the Upper Tribunal, it was certainly not particularised in the way in which it appears in paragraph 240 of the decision. It is fair to say that the Upper Tribunal made comments in the course of closing submissions that reflected a different description of the items for which the price was said to have been paid to that advanced by the revenue. But at no point was the argument put to us fairly and squarely in the terms set out in paragraph 240, so as to clearly indicate to us the case which we were expected to meet. In fact, the first time that the LLPs appreciated the case which we were being asked to meet was when the decision was delivered to us. We also say that it's nothing to the point that the Upper Tribunal's analysis as to what the price was paid for was derived from the contractual documents which had all been at the heart of the revenue's submissions. it is not realistically possible to approach this case without examining the contracts that underlie the transaction. So it's hardly surprising in those circumstances that the contracts were the focus of the submissions.
Yeah.
But we say it cannot, with respect, be right that there is freedom to run any and every argument on the contracts, provided you can tie that argument to a particular contractual provision. Then, as regards the Upper Tribunal's observation that the LLPs had the opportunity to adduce further evidence as to the amount of the purchase price that should be attributed to the CRSAs, again we say that answer misses our point. Our complaint here is that in the circumstances, the Upper Tribunal should never have concluded that part of the CRSAs, part of the price had been paid for the acquisition of the rights and benefits incorporated in the CRSAs. That complaint, that the point should never have been raised, is not cured by giving us the opportunity to come along and submit further evidence as to the value of those rights and benefits.
Can I just stop for a moment? I just want to see where this is going. Your second ground says that the Upper Tribunal were wrong in
Yes.
characterising what they saw as these benefits in the way that they did. Now, let's suppose you're right about that. Then this ground doesn't matter, does it? Because you win. They were wrong to characterise the...
Yeah, that's true.
Right.
And equally, if I'm right about ground one,
Well, that's the question.
then
Suppose you're wrong about ground two,
yeah,
and the Upper Tribunal were correct in characterising the rights as they did. Are you saying that even if we think the Upper Tribunal correctly applied the law, we should nonetheless allow your appeal on the procedural ground and leave standing a decision which we believe to be wrong in law? Is that the effect?
well, our complaint in relation to the manner in which the point was raised is that we would have wished to adduce further evidence.
Well, that's a different point. If there is relevant evidence
Yeah,
that goes to the point. Now, the only evidence you've identified is evidence of revenue practice, but I can't see that that's relevant at the moment to the proper construction of these particular contracts.
well, the issue was part of the price paid for the CRSAs, and we say that we would have wanted to adduce both factual evidence in relation to that, and also we would have wished to explore, in the context of our judicial review, whether, as there was in relation to the RSAs and the ESAs, a practice relating to CRSAs. And it's entirely plausible that there was such a practice, and I'll show you a few paragraphs in a moment, if I may, as to that. And so if there was relevant evidence on this question, that remains unremedied, even if our analysis on the particular construction that the Upper Tribunal adopted. So if we're wrong on our ground too.
So I understand the evidential point, but you're complaining at the moment that the Upper Tribunal, in effect, didn't give you an opportunity to argue the point. Well, you're going to have an opportunity to argue the point in this court.
Yes.
And either you're right about it or you're wrong about it.
Yeah. But the other element of this isn't sort of just a general whinge, if you like.
Yeah.
It's that we were denied the opportunity to adduce relevant evidence.
Right. Well,
on
that's
this
the
very,
bit that's
on this
the
very
bit
question.
that may matter.
Yeah.
So let's get on to that.
Yeah. So the evidence, in terms of the evidence that we might have adduced, it's alluded to briefly in the supplemental evidence of Mr. Fielding and Mr. Pulford, which was submitted at the second hearing, and it was submitted in response to questions from the LLP's valuation expert.
Right.
If you can briefly turn up the supplemental bundle volume A. Mr. Fielding's evidence is behind tab 6. And on page 84, just in between the two hole punches, there's a heading, Economics of the CRSAs in the context of the deal as a whole. And then he asks a question concerning his understanding of the net returns to the developer. And he says, and he asks, in order to consider the effect of being part of the wider arrangements, is the above characterisation correct? And were any other elements considered? And in response to that
Sorry, where are you now?
In response to that question, Mr. Fielding, and can I ask you to read to yourselves paragraphs 14 through 16, please?
Fourteen and 15, yes?
Well, 14 through to 17.
17, yeah.
Oh, yeah, sorry, up to and including the end of 16, thank you.
Yeah.
And then Mr. Pulford, in the next tab, he gives similar evidence to Mr. Fielding. Again, could I ask you to read 14 to 17 and also paragraph 20 of his evidence?
So he's the developer.
Yes.
Sorry, which paragraphs?
14 to 17 and 20, please.
Yeah.
So, Mr. Fielding and Mr. Pulford's understanding and experience was that CRSAs of this sort were fairly typical in EZ investments. They regarded them as commercially akin to a warranty of capital value, and also they didn't regard them as separate assets for which part of the price was paid. And we say that this is the sort of evidence which no doubt we would have wished to adduce had we been on notice of the contention that part of the price was said to have been paid for CRSAs as the Upper Tribunal defined them in paragraph 240. But by the time this evidence was served, that ship had sailed because the Upper Tribunal had already decided that part of the price had been paid for the CRSAs. So that's one aspect of the evidence that we would have wished to adduce. The other part of the evidence that we would have wished to adduce concerns the revenues practice. Now, self-evidently, the scope of the JR before the Upper Tribunal was limited to the matters which the LLPs understood to be in dispute. And as at the date of the hearing, the item understood to be in dispute, relevant to the JR, was the matter of the yearly sum, or to use the Upper Tribunal's terminology, the ESAs and the RSAs. But we say that there is every reason to suppose that the revenues practice extended beyond the ESAs and the RSAs to the very items identified by them as the CRSAs. So in paragraph 300 of the Upper Tribunal's decision, it records in the middle of that paragraph that Esputa engaged in regular correspondence with HMRC on issues relevant to the tax treatment of investments in enterprise zones. So the handful of letters that to which the Upper Tribunal was referred and which appear in this decision are the tip of the iceberg in terms of the correspondence that flowed between Esputa and the revenue as to their practice in relation to enterprise zones. In paragraph 281 of the decision, the Upper Tribunal here refers to...
Paragraph 281?
281, please, yes.
Yes.
The Upper Tribunal here refers to an HMRC memo produced by Mr. Cooper, which you'll see specifically refers to funding by non-recourse lending, i.e. on the basis that there's no recourse to the underlying investors. Now, the point of Mr. Cooper's memo is to indicate that these are the sorts of features which are typical in a greenfield site EZ investment and which at first blush might appear to be artificial, but which the revenue are nonetheless prepared to accept. Now, the Upper Tribunal describe Mr. Cooper's note as being very far from permitting 70% of the purchase price to be used as cash collateral for the bank lending. But with respect, it is not at all clear why it's so far removed. The point in a greenfield investment is that there is no other asset against which to secure the bank lending. The only asset is the cash collateral provided by the developer. But in any event, what Mr. Cooper's note demonstrates is that the revenue had certainly given some thought to the sorts of funding arrangements which often accompany investments of this nature. And cash collateral is, of course, the first of the elements that the Upper Tribunal identifies as a component of the CRSAs. So, in our submission, it is perfectly reasonable to suppose that the revenues practice extended to items such as the CRSAs, and indeed both Mr. Fielding and Mr. Pulford indicate that these arrangements were commonplace. So
neither of them say that it was their understanding that the revenue treated them in a particular way, though, do they? You've got two very experienced people who've done EZ transactions before, and they're conspicuously silent on the treatment by HMRC.
Well, with respect, they are the participants in the arrangement. Those who were very experienced as to enterprise zone investments generally were Mr. Watson and Mr. Baldwin, who also gave evidence to the tribunal in the context of the judicial review. But in any event, Mr. Fielding and Mr. Pulford may not say in terms, there was a practice and this was it. But my point is simply this: it is at the very least possible that there was a practice, and that is sufficient to establish the unfairness. Why?
Well, there was a practice, and some statement was made to you or the body representing you, and you relied on it, thus giving rise to a legitimate expectation that these kinds of payments would be treated in the same way.
Relating
so
to the yearly
it's not necessarily enough for you to say, well, there might have been some HMRC practice. That doesn't get you to the JR.
Well,
it may be it's a necessary condition, but it's not sufficient.
What we had before the Upper Tribunal was the part of the Esputa correspondence that related to the issue in dispute, which was the yearly sum, the RSAs and the ESAs. We didn't know that it was suggested that we had paid for CRSAs, and therefore we never sought disclosure of that from the revenue, and we never introduced any evidence from our witnesses as to that point. And so, but we did have the evidence of Mr. Watson, and he was the individual who had acted pro bono on behalf of Esputa, who had entered into a lot of correspondence over the years. And again, we say that given his experience, it is perfectly reasonable to suppose, or at the very least possible, that he would have been able to give valuable evidence as to the revenues practice in relation to CRSAs. And the same with Mr. Baldwin, who advised the LLPs at the time, in line with his understanding as to the revenues practice. But because of the way in which the issue arose, we had no opportunity to pursue a disclosure exercise and gather that sort of witness evidence together, which was directed at the issue of the CRSA.
So just let me see if I've got this correctly. You're not saying that there was unfairness in deciding the appeal. There was unfairness because the appeal was linked with the JR, and the evidence, although it might not have been relevant to the appeal, would have been relevant to the JR and would have led your clients to have expanded the items being challenged in the JR. Is that right?
Well, I do say we would have adduced the evidence of Mr. Fielding and Mr. Pulford in relation to the appeal as to whether...
Why should that matter? I mean, it might have been perfectly common for these arrangements, which are indivisible, to be entered into, but that doesn't necessarily prevent the Upper Tribunal from characterising.
Well, we would say that what the parties thought they were doing is material to the question of what they paid the price for. You're looking at what they paid the price for, and their evidence is that they didn't pay the price for CRSAs. They didn't regard that as a pricing issue. So how they approached the price is, we say, relevant to the question of what they paid it for. But even if you disagree with me on that, there is the issue of the JR, and we would have wished to argue that the revenues practice, just as with the RSAs and the ESAs, was not to seek to argue that part of the price was payable for the items identified as CRSAs.
Yeah.
So, for those reasons, we say that the part of the decision, the part of the Upper Tribunal's decision to the effect that part of the price was paid for the CRSAs should be overruled, with the result that no part of the price should be attributed to the CRSAs. And we say that that is the appropriate remedy, and not, as the revenue contend, to remit the matter back to the Upper Tribunal for further evidence. In our submission, remitting the matter back to the Upper Tribunal is not a fair and just response in the circumstances. It's almost 3.5 years since the first hearing before the Upper Tribunal took place. These particular transactions took place over 10 years ago, and the revenue's historic practice dates back to almost 30 years. So if the matter is remitted to the Upper Tribunal to hear further evidence, then it will be many more months before the LLPs achieve a resolution. And we say that given that the burden of proof rests with the LLPs, any defects in the evidence, or indeed the memories of the witnesses, will only prejudice the LLPs. And we say potentially very significantly, through no fault of their own. So we say that to remit this in circumstances, essentially to give the revenue another opportunity to run a point which they could have run first time around, would only serve to compound the injustice rather than to remedy it.
Essentially, you say this case is too old to be remitted.
We're saying that we've met the case that we went to the tribunal to meet, and that case itself had changed several times over the course of the litigation, and that should be an end of the matter. And it's too late now to remit it for further evidence. That remedy, all the prejudice in that remedy points one way. And it's for those reasons that we invite the court to overrule the Upper Tribunal's decision on the CRSA's issue.
Yeah.
So that's all I had to say on ground one. I was going to move on to ground two. I don't know if you would prefer to, we're 5 past, I'm certainly not going to finish in 10 minutes, but...
Up to you. If you want 10 minutes, carry on. If you'd rather stop in the morning, we'll rise now.
Well, shall we come back in the morning and have a fresh run at ground two?
I think we're ahead of the time.
We very much are, yes.
Yeah. All right, well, we'll adjourn there and we'll resume tomorrow at 10:30.
All right.